by whatever it means. One of the ways that we imagine we might contribute to these discussions sociologically is by looking at the treatment of these videos within legal settings when they make it before those settings. This is the third of a series of 3 talks which I've given on this topic over the last month. I'll give a little bit of background. On the first talk, I spoke strictly about the legal parameters associated with arriving at what was viewed as a particularly paradoxical verdict in the incident that involved Sammy Yatim and James Forcillo. The verdict that the jury arrived at was guilty of attempted murder in an incident where a police officer shot and killed an 18-year-old man. So I'm not going to go into too much detail about the actual legal parameters of this today. Those of you who are interested, my slides are online. I'm happy to talk about it after the session. The second talk, I wanted to problematize video. Video is often treated as a solution to crime problems. And there are companies such as Taser, which has now changed its name to Axon, that promote video as a solution to understanding crime. I wanted in this talk to look at video as a problem for crime and understanding crime. That even when videos show crimes occurring, they don't transparently indicate what sections of the criminal code are specifically being violated. So videos inherently involve interpretive work on the part of prosecutors, juries, and judges, as well as defendants. Today, I want to focus more on the notion of risk. And I'm a little nervous because today is my most political talk. Today I want to be a little more critical of the nature of these interactions. I won't go into too much detail here, but what I would say is that historically we've likely had the impression that video forms something of an objective observer. And I'm fine with that categorization so much as we understand that objective means unable to provide or influence its own understanding. That videos are what Gartner would call docile texts, that though they speak, they don't explain what it is that they're saying. This would be consistent with research from example Hilary Putnam and later Donna Haraway, who are critical of the idea of an objective observer, providing a God's eye view of different social processes. What we'd say is that video of violence by its very nature is inherently interpretive, and that the viewer must understand this through things such as appropriate moral protocols and valences, interpretations of the actors involved, and other situational features. Prime examples of this would, of course, be Aaron Doyle's research on the crime program Cops and the editorial practices involved in accentuating crime problems witnessed on that show. But more specifically to this research, Chuck Goodwin's analysis of the Rodney King beatings and videos associated with that treatment in court, where in 2 separate trials, a civil rights trial and a criminal trial, the juries arrived at 2 separate verdicts. The officers involved in that incident were found not guilty in the criminal trial, but they were found guilty in the civil rights trial. And the same video was crucial evidence in both trials. So, once we get to the point of understanding that video doesn't do all the work for us, we have to start understanding what work video does do. Our vision is to do this on a case study basis, and as I mentioned, I'm looking specifically at the Sammy Yatim case today. However, we do have an eye to some of the other cases that have occurred over the last number of years, and I'll sort of speak a bit more to them today. I hadn't touched on them before. Nevertheless, what we want to do with this is not so much scholarly engagement, although we see this as an opportunity to forward our understanding of perception in a sociological manner. We really see this as an opportunity for public engagement and an opportunity to move away from the expert witness model of interpreting videos in corporate settings. I'll come to that at the end. Just by way of conclusion to our introduction, I would say, or my introduction, I always do this where I say our, so it's sort of figuratively. Videos of police-public interactions are often cited by the police themselves as being instructive in understanding their actions after the fact, especially when they're interpreted by expert witnesses. So a close analysis of their official use seems warranted as a check on police authority and judicial oversight. Now, on July 27th, just after midnight in 2013, Sammy Yatim was on board a Toronto streetcar. He withdrew a 12-centimeter switchblade knife and he ordered the passengers of that streetcar off. Shortly thereafter, Toronto police arrived on scene, and in about a minute after they arrived, Constable James Forcillo shot and killed Sammy Yatim. Approximately 2 weeks after that incident, Forcillo was charged by the province's Special Investigations Unit with second-degree murder. And then a year after that, the Crown Prosecution Service added a second charge of attempted murder. And this was met with some curiosity because, of course, attempted murder is a lesser included offense made in law to attempted murder, or to second-degree murder. So if the Crown Prosecution Service didn't think they could convict on second-degree murder, they would have been able to ask the jury to consider attempted murder as an alternative. Nevertheless, the trial went ahead, and in January 2016, Forcillo was acquitted of second-degree murder, but he was found guilty of attempted murder. Now, this raised some questions in the popular discourse. For instance, how could somebody be convicted of attempted murder for someone they killed? For us, we're likely more familiar with the legal wranglings associated with this issue. If not, I'd be happy to speak to it later, but I'm going to overlook it today, or at least now. For us, questions are more about how does the video make both the charge and the verdict possible, if at all. I'm going to show the security footage from the TTC right now. I don't want to take anybody by surprise, but it is quite graphic. You will see the team being killed here, and it's a way of a trigger warning. I'm still triggered by this, and I've seen it quite a few times, nevertheless. I'm going to talk over it. I've edited it down to just the moments where the police arrived. So you can see that the team has recognized the police are arriving. You can see the squad car lights shining. And he brandishes the knife, and he's ordered to drop the knife. And he sort of makes this surrender gesture, but then he becomes quite belligerent and aggressive with the police arriving. You can see here, this is Constable Forcillo and Constable James, his partner, arriving. They arrive with guns drawn. Constable Forcillo's gun is in the raised position, ready to shoot, and James' gun is in the low ready position. But you can see that she holsters her weapon here, and she asks if anyone else is on the streetcar. This is what's called a de-escalation procedure. And Forcillo doesn't participate in that de-escalation procedure. He continues to order the team to drop the knife. You can see more police arriving, vaguely, and Yatim moves away from the streetcar door, but he's still brandishing the knife at this point. Now, Forcillo issues the lawful order. If you take one step closer, I'll shoot. Yatim stands back for a few moments, and then he moves into the streetcar door and is shot. Initially 3 times, and then there's the 6-second pause, and Forcillo opens fire again 6 more times. Now what's important here is that 6-second pause. This 6-second pause was argued by the Crown Prosecution Service to indicate that this shooting was actually comprised of 2 separate transactions. The first volley of 3 bullets and the second volley of 6 bullets. The second-degree murder charge was tied exclusively to the first volley of 3 bullets. The attempted murder charge was tied exclusively to the second volley of 6 bullets. And that pause serves as a common-sense delineation between actions, and that is the legal criteria by which we establish what a transaction is comprised of. I thought that was amazing. There's no legal definition for what a transaction is. Now, in terms of the legality of Forcillo's actions, in the moments just prior to the initial volley, Forcillo perceives Yatim subjectively to be both in possession of the weapon and moving into a position to use that weapon, progressing from the streetcar passenger area into the streetcar door. In this case, the defense argued, and the jury accepted the argument, that this allowed for Yatim to be subjectively perceived, as posing an imminent threat to Forcillo, and as such he was justified in shooting in that instance. Now, in the second transaction, you can see vaguely, especially in the image on the right, that Yatim is on his back on the streetcar floor. And what's testified to in court is that Forcillo perceived Yatim to be reaching across his body to pick up the knife which he had dropped. He places it back into his right hand, and then Forcillo testifies that he saw Yatim raise his body to a 45-degree angle in a preparation to re-attack. Now, this ran contrary to evidence presented by the coroner, which indicated that Yatim had been paralyzed in the volley of the first 3 bullets, and as such, he would have been medically unable to raise his body in the way that Forcillo had suggested. So legally, this comes down to a differentiation between imminent threat and potential threat. In the first volley, Yatim's holding the switchblade knife, and he's in a position to use it, which means he can subjectively be perceived to be posing an imminent threat, in which case lethal force is warranted. In the second volley, Yatim has rearmed himself, but he's no longer in a position to use that knife. And you are, according to Toronto Police Services procedures and protocols, you are legally entitled to be in possession of a weapon and not pose an imminent threat. You must be in a position to use that weapon. In the case that you possess a weapon and are not in a position to use it, you only pose a potential threat, and lethal force is excluded on behalf of the police on that instance. So the video in court was effectively used to settle a debate between the coroner and Constable Forcillo as to whether or not Yatim would have been physically able to conduct the actions that Forcillo had testified that he had. Now I'm going to move away from the incident itself, and I want to get a little more detached from this for a moment. I want to consider the ways that the legal proceedings bracket the interpretation of risk as being a perceptual issue between Forcillo and Yatim alone, rather than Forcillo and his 4 colleagues against Yatim. There's some practical legal reasons for bracketing this risk. The first is that Forcillo is the one who is at trial, and as such, the legality of his actions is established based on his perceptions alone. There's a long-standing body of psychological research that effectively validates the common sense notion of tunnel vision, that at times of great stress, people will narrow their focus down to the thing that's causing them that stress. They will only see the attacker. But crucially, the legal framing of the problem is in relation to what Forcillo perceives Yatim to be doing in an accused-victim binary exclusive of externalities, including other police on the scene. I want to show one of the viral videos here. This is the first time I've showed this in the conference, but this is all readily available on YouTube. And if we consider this alternative video, we have very little record of Yatim's actions, and perhaps a slightly different impression of the perceived threat that Forcillo is facing. Forcillo is positioned well back of the streetcar door and is surrounded by other armed officers. The streetcar doors are covered, as we're about to see. The camera will pan over, and there's another police officer. I believe this might be Officer Kim. I'm not quite sure which one is Officer Kim. But as you can see, there's very little evidence that there are other passengers on the streetcar, and Yatim may be posing a threat to the public. We can't say that conclusively, but nevertheless, we're building evidence here. So again, there's good reason to consider the security footage as significant. The security footage foregrounds the nature of this interaction as occurring between Forcillo and Yatim. But when we watch this video, are we willing to come to the same conclusions about risk? Now, of course, sociology has a fantastic heritage in treating risk. We harken back to, of course, Beckett Giddens and in relation to police work, Erickson and Haggerty's adaptation of Beckett Giddens. But I think more importantly for this type of analysis, we might look at Diane Vaughan's treatment of risk in relation to her analysis of the Challenger disaster and the post-disaster accounts that were given before a Senate committee. So the key issue for Diane Vaughan was that risk is conceived inside an organization and by different actors in that organization, and those conceptions are not necessarily congruent with how external auditors may also perceive those risks. Vernacular treatments of risk through language such as acceptable risk, acceptable erosion, or waivers were treated as markers of deviance by the Senate committee examining the Challenger disaster, but they were entrenched in policy documents and procedures at NASA. They were rules, not deviations from the rule. What we might conclude is that threat or risk are highly interpretive phenomena tied to occupations, perceptions of stress, and other issues at the scene. Now, because the legal treatment of this incident is based exclusively on Forcillo's plausible accounts of his subjective perceptions of the threat posed by Yatim's as expressed through Yatim's movements and behaviors and the use of security footage, makes sense under those conditions. The security footage directs the viewer's attention specifically to Yatim and Forcillo, and is perhaps effective in bracketing out the externalities of the other police on scene. However, we could be tempted to interpret this as exhibiting something of a bias in the way that Doyle uses the term. In this case, Doyle's discussion of security footage points to a more subtle aspect of bias, such as where cameras are positioned and the types of activities they make visible through that positioning. We might adapt this to consider how the individual police perception is bracketed in relation to the threat they are facing, rather than the force they themselves comprise and represent. So a preference in the legal treatment of these videos, or a bias in the legal treatment of these videos, is to reduce the subject to the consideration of the accused victim pairing. A question we may be tempted to ask in response to this is, are we justified in perceiving an 18-year-old wielding a knife as a legitimate imminent threat to 5 trained and armed police officers? Now, of course, this incident has not occurred in isolation. There has been a proliferation of police incidents, or at least a proliferation of videos of police incidents involving white police officers shooting and killing unarmed men of color, in most cases either armed with light weapons or no weapons at all. Just last week, Officer Betty Shelby was acquitted of manslaughter charges in relation to a shooting and killing of Terrence Crutcher in Tulsa, Oklahoma. Shelby testified that she was overcome with fear at the moment of the shooting, that Crutcher had repeatedly ignored her orders to lay face down on the ground, and that she suspected that Crutcher was high on PCP. Now we can see here that Officer Shelby is not alone. In fact, she wasn't the first to shoot Crutcher. Crutcher was first shot by another officer with a taser. These nearly happened simultaneously. The jury blamed the prosecution in this case for putting together a sloppy case. They wrote a letter to the police chief saying Shelby should never be a patrol officer again, that she was too timid by disposition, but they acquitted her all the same because she was overcome with fear, and that fear was an overriding factor in her decisions. Here we might see that fear, or perceptions of fear, is an overriding factor within the justice system. The Michael Slager incident. Michael Slager shot and killed Walter Scott following a routine traffic stop. During the interaction between Scott and Slager, there was a physical altercation. There is some debate as to whether or not Scott may have acquired Slager's taser in the process. Nevertheless, Slager shot Scott as he was running away, and he shot him from a distance of at least 17 feet. Again, fear was an overriding factor in Slager's descriptions of his perceptions during the event. This resulted in a mistrial due to a hung jury. And it came down to one juror who said that he could not, in good conscience, convict a police officer who was on the job. The case will go to retrial. Timothy Loman got fired on Tuesday. He was the police officer who shot and killed Tamir Rice. Tamir Rice was a 12-year-old child who was bearing a pellet gun or an air gun, an air pistol, near Cleveland, Ohio. Ohio is an open carry state. It was a toy. He had every right to carry not only that toy, but also much bigger weapons. The grand jury decided not to indict him. There wasn't enough evidence, but he does face administrative charges. This work has evolved out of an ASA talk that Mike Lynch gave last year in Seattle, where Lynch saw fit to address the use of expert witnesses in court. Now Mike's history is scholarly history has very much to do with analyses of expert witnesses. His call for popular vision seems prudent to me, especially in the case that he was examining or is examining. Is the case of Laquan McDonald, who was shot and killed by police in Chicago. Laquan had been followed by police for about 10 minutes prior to this incident. The video is quite long. You can see here again, police arriving in overwhelming force. I count 4 police SUVs confronting Laquan McDonald at this point, and then Officer Jason Van Dyke opens fire. Try as I may, I can't make sense of it. Jason Van Dyke is going to face 6 counts of murder and 18 counts total. I got 18 or 19 counts total. I was reading the Chicago Tribune this morning to make sure I was up on this, to make sure it wasn't back. It's first-degree murder that he will face in relation to this incident. But again, I think we're going to hear notions of risk discussed at trial and perceptions of fear. All right, in way of concluding where I think sociological as well as the impact that sociology may have outside of these environments Videos, of course, afford certain interpretations of these events, but our understanding is sought in accordance with legal codes, and understanding what's seen in video as in accordance with the general sets of laws that we have set to govern police behavior and the behavior of others. So really, I think the question that we might ask is about notions of bias within the legal system and how we frame notions of risk as perceived by police officers. I wonder if it's not time that we widen the interpretive field